Good afternoon, everyone. My name is Marie-Bénédicte Dembour. I am a professor of law and anthropology at the University of Ghent, where I lead an advanced research project, an advanced ERC research project called DISSECT, Evidence in International Human Rights Adjudication. And as part of this research project, we are starting a Talking Evidence series. We're starting today, it's our first episode. And in this first episode, we're going to talk about judicial truth, a highly relevant topic at all times, but possibly especially now. We're going to ask a number of questions or address a number of questions like, what is judicial truth? How different is it from other kinds of truths? What might it miss out, but what might it also capture? And to help us thinking about this very big topic, we have two anthropologists. We have Dr. Sandhya Fuchs, who at the moment is doing a Leverhulme early career research fellowship at the University of Edinburgh, and Professor Jessica Greenberg, who is at the University of Illinois, currently writing a book on ethnographic perspectives on the ECHR. And in fact, at the moment, she is at Strasbourg doing fieldwork. So it's great that we can have this conversation. I think you're going to hopefully enjoy it as much as I think I'm going to enjoy it, because both Sandhya and Jessica's work is absolutely so valuable and so stimulating. So the first thing I'd like to ask, possibly Jessica first, is for Jessica to introduce herself to you so that you know where she's coming from and in a sense why she likes to talk about judicial truth with us today. Okay. So over to you, Jessica.
Thank you so much, Marie, and thank you again for the invitation to be here and the opportunity to have this space to talk about questions of judicial truth, and also to engage with your work and Sandhya's work, which has been really, really exciting and productive. So I'm just going to give a few minutes overview, try to keep it relatively simple about the kinds of questions that I'm interested in asking in relationship to judicial truth and in relationship to human rights in Europe and human rights more broadly. So as Marie indicated, I am currently doing a research project and working on a book on the European Court of Human Rights and the European Convention on Human Rights system. And I know there are a lot of folks in the audience who are already familiar with the system and many who aren't. So I'll just, to give a general sense or an overview, for those who aren't familiar, and sorry, my screen seems to be freezing. Can you hear me okay? Or yeah, getting some frozen screen. Okay. So the ECHR system is actually part of the Council of Europe. It's not an EU court. Sometimes people confuse that. It's part of the Council of Europe. And so it means that it is a human rights court that issues binding decisions on 47, soon to be 46 countries across the European space, and has relevance for individuals, over 800 million individuals across Europe in the participating states. And one of the things that I think is particularly interesting and exciting to think about something like judicial truth in relationship to the convention system, the European Convention system, Human Rights Convention system, is that it allows, and it's one of the only, not the only, but one of the only apex courts or sort of the high courts that allows individual application. So it's one of the few institutions in the world where an individual can take a state to court for violation of human rights. And because of this unique feature, this unique individual right of application, it also raises a really, really interesting question, which is one of the research questions that I started out with when I began this project, which is, how can an institution that in some ways presents itself as this capacious, framework for something like human rights and justice across a European space. And the system does, to some extent, presenting itself as the conscience of Europe. And there's a lot of investment in the kind of value-based ethos of the Council of Europe, but also the ECTHR. How can a system that has a sort of capacious vision of human rights and justice get to that kind of vision one case at a time? And so one of the questions I'm really interested in thinking about the convention system is the extent to which the additive logic of one case plus one case plus one case, with all of the sort of evidentiary standards and all of the kinds of doctrines and all of the kinds of case law that apply to specific instances of human rights violations, become something potentially more. What I think of as a kind of shift from the quantitative of one case to the qualitative of something like justice. So that's one question that I'm interested in, and I think it has a lot of relevance to the question of judicial truth and who it's for and what we do with it and what kind of audiences it implies and invites. The second question then I'll stop, that I'm interested in looking at, is the way that beyond the court or any one case, the convention system itself, the ECHR system itself, is something like a communicative infrastructure. And what I mean by this is it is an institutional and legal and political framework for a group of diverse actors to coordinate in sort of semi-coordinated ways to think about binding questions or shared problems, again, that speak to things like, what is the nature of European belonging? What are the limits to nation state sovereignty? What is the proper evidentiary regime for forms of state violence, especially visibilized forms of state violence? These kinds of questions, and what does justice mean and look like? And so the other set of questions I'm approaching the project with is really about how does law become a space or framework for people to ask and answer questions that in a way that actually have legal and political consequences down the line. And again, it raises issues around judicial truth, but also whose truth and when and how those kinds of truths are a collective achievement, kind of collective semiotic achievement that come out of this communicative infrastructure. So those are the kinds of questions that I'm asking, and a little bit of the context and background of the bigger frames. That maybe got a little abstract quickly, so I'm going to stop there, hand it over to Sandhya, and we can circle back to make it more concrete.
I'll come in first, if I may. So thank you, Jessica. So one point I would like to insist from what you have said is that the court you're looking at, which is a court of human rights, it's the European Court of Human Rights, that court's task is to decide whether a state is in violation of human rights. So mostly it's going to be individual applicants. You said that, but I want to emphasize nonetheless, it's going to be someone, it could be you, it could be me, it could be anyone else in Europe, or someone who is under the jurisdiction of the states, who bring a case to the European Court of Human Rights saying that state has violated my rights under the convention. And so I'm not going to say much more than that at the moment, except maybe to say they need to have exhausted what we call national remedies. So they will first have gone before the authorities of the state that they say have violated their rights, go through the judicial process there before being able to go to the court. So in fact, there will already have been a story and collection of evidence at national level that the court will then take into consideration, possibly with some exceptions. Now I'm going to turn to Sandhya, and I'm going to ask Sandhya also to introduce herself and to say why she's here. But I will just draw your attention to the fact that Sandhya is actually dealing with another type of court, with a criminal court. And in a criminal court, you have the representative of the state, so the prosecutor, accusing most often an individual to have committed a criminal offense. And so both the evidence regime is going to be quite different. And also the purpose. The purpose there is to decide whether someone is guilty as a criminal person. So but that's very different from the human rights setting. So I wanted to make that clear right from the start. But over to you, Sandhya.
Yeah, thank you very much for having me today and for allowing me to have this great conversation with all of you. So yeah, as Marie already said, kind of moving from human rights, international human rights, to more of a national level, I'm just going to give you a brief kind of overview of what my work has explored and is currently exploring, and also, like Jessica, some of the main questions that come out of that. So my ethnographic work has been focused in North India and has focused on analyzing how personal experiences of discrimination and hate are addressed through special criminal laws and hate crime laws in particular. And then specifically what that means is that I've tried to analyze how long histories of oppression and the kind of the collective memories, the stories, the narratives, and the experiences of violent exclusion that come along with that, and that marginalized communities narrate how all of that is translated into and addressed through hate crime laws. And I've done this ethnographically in India by specifically focusing in on how competing ideas of justice and progress and truth come into play when special criminal courts in India take up the fight against practices of caste discrimination, which is really a very layered, very complex, and very normalized form of discrimination and prejudice, which is woven into the everyday fabric still of Indian life, even though it is outlawed. It's, you know, it's still there. It's very invisible a lot of the time. And so currently the research I'm doing in Edinburgh focuses specifically on conflicts over hate speech, and I've just started this, so it's in the pre-fieldwork state. But the idea is here to analyze specifically how judges consider longer histories of communal violence and exclusion when trying to establish whether a particular moment of speech was kind of motivated by hate or not. And that research really grows out of my previous project, my PhD project, which explored the social, political, and also the emotional life of the only hate crime law in India to date, which is the Prevention of Atrocities Act. And to just give you just a teensy bit of background on the Atrocities Act. So the Atrocities Act is meant to protect two communities. One are Dalits, which are ex-untouchable groups, and the other ones are Adivasis, which are indigenous groups, from targeted violence motivated by, you know, caste prejudice by other castes. And it does that in a number of different ways, but one way it does that is in sort of very classic hate crime law logic, that it enhances punishments for offenses under the Indian Penal Code when they are committed against a Dalit and Adivasi. And so I conducted a lot of field work in the North Indian state of Rajasthan with Dalit complainants, with legal aid NGOs, with police, and with judges at the district courts and also at the High Court in Rajasthan, and try to sort of trace how individual particular moments of caste-based violence were kind of translated into cases under the Atrocities Act. And what was very sort of fascinating in what came out of these like ethnographic moments and this analysis was that there was a particular conflict that kept coming up again and again about this idea of truth production in courts. And what my research showed is that judicial methods of assessing what like constitutes a true complaint of caste discrimination were so often at odds with the visions and the practices of truth that survivors of caste-based violence sort of held on to. And that incompatibility was really rooted in very different engagements and methods of engagements with local contexts and local history. And as a result of that, you know, a lot of cases under the Atrocities Act that are dismissed as sort of unfounded or as false complaints by courts are usually not actually false at all from the perspective of Dalit communities. And sometimes even the cases that are sort of stamped as false by courts can really speak to much deeper sort of structures of discrimination and moments of prejudice than cases that courts declare true. So there's quite a sort of difficult dynamic there. And so the final question that comes out of this, and I'll end it with this, just sort of open up the floor now for the debate, is that what I've been really trying to explore in my work is what systems of truth production or what different regimes of truth are at play when we try to make hate crime laws work, and what real life effects and consequences these sort of competition and the incompatibility between judicial avenues of truth making, kind of local perceptions and contextual perceptions of truth have on the lives of the people who turn to hate crime laws for protection. And we'll just leave it at that for now.
Okay, thank you, Sandhya. I forgot to say something in my introduction to criminal law, is that you said there was a complainant, and I didn't say that. So there is someone who comes to the police in India and who says, I have been a victim of hate crime. And then it would be for the police to investigate this, and then it would be for the court to decide whether the person who has been alleged by the alleged victim to have committed that crime has actually committed the crime. Now, Sandhya, could you perhaps give us a concrete example of a case where there have been these different ways of looking at truth? Because you say on the one hand, there is the historical truth of discrimination. Maybe there is also the current truth, the current social truth of discrimination. And then, being familiar with your work, I also know there is then possibly the judicial truth that would come up with the conclusion that in fact, in this particular case, there has been no discrimination. Or, just tell us a little bit more, because I think it's going to help understanding what we're talking about.
Sorry, yeah, definitely. So I think the one thing there's two parts to this question, right? And I think the one thing to know around the dynamics around the Atrocities Act in India is really that it's a law that has often been accused, not just by sort of the public, but even by the Indian Supreme Court, of being a law that produces a lot of false accusations. And that's a very dominant sort of narrative, which has been employed at multiple junctures to potentially sort of curb and kind of slash the law a little bit. And what's very interesting about these false cases is that they can kind of be the result of two different things. They can be the result of people literally just not having the economic or social or financial sort of networks and resources to really engage with legal institutions, which is something we can talk about more later. But the other thing is that a lot of the time, people, members of Dalit communities in Rajasthan felt that there was sort of a judicial truth which was quite surface level, which was very moment focused, had very little depth, was kind of a narrow snapshot of a particular interaction and quite unilinear. And then there was kind of a complex layered village truth of the ways which kind of had, it basically were different layers of the way discrimination was kind of apparent in village or a town life, and which was more holistic. And they had this idea that a lot of the time, like the sort of judicial truth didn't do what people on the ground did when they realized that something was discriminatory, which was to look at an incident both sort of horizontally in terms of like wider happenings in village life, and vertically also sort of going more deeply into village or even national history. So there's this idea that, you know, sort of experiential truths of discrimination they're like broad, they're holistic, they go in all kinds of directions and they're layered, versus judicial truth, which is kind of this very narrow bureaucratic snapshot. And the best case probably to illustrate that is an incident that happened in the fieldwork village I was staying in, where a young Dalit man basically got into a bit of a scuffle with a very wealthy higher caste landowner who was very powerful in the village. And so this Dalit, or, you know, ex-untouchable boy, he was in hanging out with his friends one day, and they ended up in this very wealthy landowner's field, and they were drinking. And this higher caste landowner got wind of it, and he came over and he got very mad at them, and he yelled and tried to get them off his land, and basically told them that they were disgracing their families. And so this one Dalit boy got very mad, and he took a stone and he threw it at this guy. And as a consequence of that, the landowner, the wealthy upper caste landowner, he went to the hospital, but he also immediately called the police, and a bunch of police officers appeared, and they took all 4 boys and they basically arrested them and kind of basically threw them in jail. And and basically just kept them there for quite a long time without kind of processing anything or investigating anything further. And so because they were locked up in there, there was a local Dalit lawyer who told this young man who had thrown the stone that if he wanted to get out of jail at all ever, that he should file kind of an accusation of hate speech under this Atrocities Act against the landowner, because that would humiliate this guy and potentially affect his chances of getting elected for a local political post. And so they did that. And as a result, the landowner kind of had the boys talk to the police, had them released, and in exchange for them dropping the case. And, you know, that story is kind of, it sits really uncomfortably. And this sort of case, this incident very much like entered the record of like this sort of discourse of false cases in the area and in the state of, in terms of like, look, there's this boy who's filing this false case and lying and abusing this very powerful law. And but there's like much more to the story actually when you look deeper. And while kind of the Dalit community in that village felt that boy, you know, was wrong in some ways and was an idiot and kind of immoral, they also didn't actually think that case that he had filed was false. They didn't think that what he accused this landowner of, which was kind of cast as hate speech, was actually a lie. And they didn't think that for 3 reasons. One was that this guy had actually used kind of cast as slurs against his Dalit laborers, but also against different Dalits in the village before. And so they were basically like, well, it might be displaced in time. It might not have been at this moment, but he's done this before. And the other reason was really that they felt that the dynamics that had unfolded when this landowner threw all of these boys just in jail, and basically with the police completely obeying his orders and not kind of giving these young men any kind of chance to defend themselves, really spoke to deep structures of caste inequality and to this like disproportionate power of this upper caste landowner. And they basically said, you know, if it had been the other way around, we wouldn't have, if we had filed a case against this guy or went to the police accusing this guy of beating us up or something like that, nothing would have ever happened. And so the case actually does we are kind of filing a case which is us trying to gain some sort of leverage in a society which has put us all in a situation where we don't have any leverage. And finally, they also felt that was really necessary. It wasn't really a choice, because it was necessary because their families, these boys' families, were quite kind of economically, well, they weren't very economically secure. And their families relied on all of these boys for daily income and for working the fields, and without them, you know, there was a real possibility of the families kind of literally not having enough money or having enough to eat, or, you know, being basically destitute. So they also felt like the case didn't just speak to broader truths of like structural inequality, but it was almost like a necessary step to even address that. And they thought that the Atrocities Act was really a law which was about this promise of alleviating structural inequality and caste oppression, rather than something that needed to focus on like this one instance. So that's just one example of how, you know, they had a much sort of horizontally and vertically broader vision of truth than kind of the police would have, or that even, you know, court analysis of a complaint like that would have.
Okay, so a rather complicated case, which you say, you know, kind of sits uncomfortably. So basically here we have a young man doing something wrong to a upper caste man and ending up in jail. And in order to get out of jail, making what we can only call like in a kind of objective, factual manner, a false accusation against this upper caste person by saying that. And so that gets them then out of jail. So a lot of complicated stuff. Now, I also know from your work that, and we'll probably talk about that later, there is also a lot of cases where the Dalits do accuse an upper caste, if they dare to, of something which has really happened, and then they're not successful, and their cases is being dismissed, and that is also being considered as false cases because they don't get anywhere. So in a sense, the false cases are the true cases, if I go too far. And in a sense, the successful case, at least in this case, is what we would call as the false cases. So, but you said, in a sense, this false accusation on the fact, nonetheless, resonates as being something true for a number of people who understand what the situation is historically. So lots of layers there. Jessica, can I turn to you and maybe ask whether, to you, you know, when we talk about judicial truths possibly being different from a different kind of truths, what would that call into your mind in the CHR system?
Sure. Yeah, thank you. So, I mean, I think I have an example too that I want to track through a little bit. And I think one of the things that is interesting about the idea of a judicial truth is that in some ways, in an ideal context, right, a judicial truth is enabled by a series of parameters, right, for what counts as evidence or what counts as a harm, right? And in some ways, what is interesting and useful about a judicial truth in a legal context is that, again, in an ideal sense, everyone should know what those parameters are, right? So this is what evidence looks like, and we know this is what evidence looks like because we can refer back to case law, or we can refer back to doctrines of interpretation or standards of evidence or this sort of thing. And I think that's one way to think about judicial truth, as a kind of almost hermetically sealed set of relationships that happen within the law itself. But I think, as Sandhya's example points out, and the one I want to talk to about as well, is that those terms for truth, what counts as truth, often hide or erase underlying structural conditions about who can actually generate that kind of evidence, or what that, you know, what that kind of evidence looks like. And so what I think is really interesting is to think about not necessarily the truth produced in the context of a court or a case, but about the way in which a judgment itself is the product of a series of different points of accumulating evidence oriented towards different audiences over time. Right. So here's an example. That's a little bit of abstract. So here's an example of a case I've been thinking a little bit about. And it is a case that begins in 1974 in Cyprus, in northern Cyprus, the Lazadu case. And it is an instance of property, a question of property restitution. So a woman in 1974, when with the invasion of northern Cyprus, a number of people flee, they're refugees, they lose property. And one case in particular finds its way to the European Court of Human Rights and gets a judgment, although not until 1996, right? So already you have a very long process of accumulating evidence within a conflict context, but also within a domestic legal system. And eventually the case comes to the court. And interestingly, the European Court of Human Rights finds that there's been a violation in this case, and that there needs to be some sort of mechanism for restitution, but the judgment itself doesn't actually indicate at all what that result should be, or what that actual that mechanism should be, and so it actually refers it onto. So let me step back a second. The interesting thing about the European Court, the convention system, is that it's split institutionally into a kind of legal arm, the court, right, which is sort of governed by case law, it's governed by doctrine, and very explicitly and self-consciously people understand it to be the site for the production of a particular kind of legal truth and legal reason in relationship to case law. But there's also a political aspect to the system, which is the execution system. And so what happens is a judgment moves from the court across the street to the Department for the Execution of Judgments, which is the secretariat which supervises the Committee of Ministers, the executive branch of the convention system. And at that moment in time, a legal decision becomes, it maintains the authority of a legal court decision, but it has to be implemented within a kind of political context. And so the law, in some sense, enables a body of evidence to be accumulated and an assessment to be, of a violation to be delivered. But the actual implementation of that judgment suddenly moves over into a kind of political space. And so what happens to the judgment is it's interpreted very, very differently as it moves from a legal to a political space. And so what happens with this judgment, and I wanted to read actually a few quotes from interviews that I've done recently. So this case is decided in 1996. And the court basically says, yes, there's been a violation, but we're going to leave it to the applicant and the state and the Committee of Ministers essentially to develop some sort of actual mechanism for how we're going to resolve this legal issue through reparations. And the case stays open for decades, essentially. The case is still open. And in that process, a whole bunch of other actors sort of come into the picture and take a look at the judgment and take a look at the context itself on the ground and say, how do we actually take a legal determination, right, a kind of judicial truth, and turn it into something like operable human rights on the ground? And that requires a whole bunch of knowledge and evidence far in excess of the narrow legal definition that allowed for the finding of a violation itself. And so what I think is important to think about in this process is that as a judgment moves from a legal to a political context within the same kind of human rights system, the meaning of information and the relevant context that people bring to bear in order to extract something like a judicial truth in the name, not necessarily of a legal definition of a human rights violation, but in the name of something like reparation or justice, shifts. And the process itself is bound by the judgment, right? If there isn't a judgment, if a violation isn't found, some sort of reparation or response isn't justifiable, it can't be authorized, right? So the judgment itself forms the kind of legal authorizing framework for something like an intervention on the political or geopolitical side, but the judgment itself isn't enough, right? People then need to bring to bear a whole range of other kinds of interpretive and evidential materials in order to make the law live, right? In order to make the law actually kind of real in a reparative sense on the ground. And that's where it begins to get really, really messy. And so I just wanted to read, if I can, a few quotes that came up from some very recent interviews about this case and about what happens to a narrow judicial decision, right, grounded in a particular evidential regime as it moves into the so-called real world of execution. And I think what I hope you'll see in some of these quotes, and these are quotes by people who are familiar from the kind of legal and diplomatic side with what it means to execute this judgment and call it closed. And I think you'll begin to see the way in some of the conflicting notions of truth and evidence begin to play out, as well as the conflicting sense of sort of justice and ethics that those judgments, or that the judgment kind of invites, how it plays out. So these were 3 interviews that very coincidentally happened to be within the same week, and in each one, because the case is very much on people's mind, people brought it up in the context of thinking about what it means to close a case. So I was talking to one person at the council, and she said to me, my country approaches the question of closing a case as a legal question. Some colleagues interpret the process through a geopolitical lens, but we don't agree with that. For example, with an ongoing case about to be closed, say Cyprus property rights, for example, we're debating whether the case is ready for closure. Our country approaches from a legal perspective. It's how we approach other cases as well. Other delegations see it through the angle of geopolitics. And interestingly, a few days later, I was talking to another interlocutor who was familiar with the process of execution, who said about this case, look, legally it should close. There's been a resolution, there's been a legal resolution for it, but there's a ghost behind this case, the ghost of a truth, the truth. Somebody occupied the land illegally and basically is buying off that land. Something looks right, but it isn't. And you have to ask, essentially, why is the court washing their hands of it? A few days later, I had another conversation with somebody, and interestingly, in an oblique way, the issue came up again. And she said about closing case, yes, it drives you mad. The frustrations are enormous. This goes on years and years. And you know the poor people in Cyprus or Moldova will never get to a situation where their property is restored or their school books are the way they should be. But you also realize you have to move towards closing the cases, no matter how frustrating this is. That history is, even if you know it's not going to happen, history is cruel, and the plight of individuals is really cruel. It can get under your skin, but your goal is to close the case because the decisions of a court need to be executed. And so I just wanted to offer that example from a kind of the perspective of a legal truth that emerges out of a strict kind of doctrine and case-based, that yes, there is a violation, but the question of truth doesn't by any means end there, right? It animates a whole sense of other questions about what our responsibility to something like the truth is, or our responsibility to the legal system itself. Sorry, I went on way too long there.
I cannot help asking, is this loisy-do or not? The case? No, yeah, apparently it's not.
Yeah,
Okay.
it's. I mean, the records are public for this case, so yeah, it's not violating any confidentiality to say that this case is very out there and people are talking about it. Yeah.
Well, as someone who has worked on the ECHR system, it's a case, and this is how lawyers talk. lawyers will say just the name of one case, and we already have kind of a whole legal story and legal truth. And basically what you are telling us is that the legal truth of the judgment, that there is a recognition of a violation that has happened, does not tell you what's going to happen next. You know, to me, what was interesting when I was preparing this talk is that I came across a number of qualificatives for the judicial truth. The judicial truth would be flat, or it would be superficial, or it's missing the contextual. It's quite like the case that Sandhya was giving. I assume, you know, a lot of lawyers would be horrified if a case is successful while the core accusation, even though they regard it as true in some sense, was not true in the narrow. That's the other word which often comes up, the narrow sense of the term. So I think what is clear is that, you know, the judicial truth is not the whole truth. I mean, it's not meant to be the whole truth. And I think it would be quite interesting to discuss, you know, what is being lost or what is being gained. You know, we're not going, I don't think we're going to change the Western perspective of law looking for trying to capture objectively true facts. Now we know what does that mean, but nonetheless, we even though we have difficulties with that, this is what the law is trying to catch, I think. And then I think it may be interesting to kind of think about what it allows, but also what it misses. I don't know, Sandhya, whether you have any thought about that.
I have, thanks, Marie. I have lots of thoughts about that. I think just maybe just a little comment on both of these things. I think in terms of like what it misses, I guess maybe one adjective that I would use, maybe not in terms of judicial truth across all issues in all jurisdictions at all times, but certainly in relation to judicial truths around discrimination, is that it's paralyzed. And I think what I would sort of maybe one example that I can just use to demonstrate that is, you said earlier that there's a lot of cases also that get classified as false that are just also like factually, objectively, in the narrow sense, in the immediate sense, in the case sense, true. And I think so there were so many people I encountered during my fieldwork who were, you know, Dalits from sort of socioeconomically fraught situations. They hadn't had a lot of educational opportunities, didn't have a lot or any land, were quite dependent still of kind of on like traditional agricultural hierarchies. Maybe they were working for an upper caste employer who, you know, really suffered from caste violence, but they had no, and this goes back to Jessica's kind of comment around, you know, institutions and institution holding a particular kind of, building a particular kind of case. They had no sort of access or opportunity to ever really make a legal file that could act as proof of what they had. And I think, so, you know, a really obvious example is this young man whose father was murdered by his higher class employer. And people in the village knew that this higher class employer had murdered him because they were witnesses who had overheard screaming in the fields. The body bore marks of torture, you know, and sort of the Dalit community and there was a background where like there was a big dispute between this guy who had been killed and his higher caste employer in terms of wages and unfair wages. And so everybody in the Dalit community in the village sort of knew that this is what had happened. But this young man who filed a case under the Atrocities Act to sort of, you know, get justice for his father's murder, he could not for the life of him get any evidence. And he always said that, like, people like me can't get evidence. Like the police wouldn't pursue the case because the employer had a lot of power and bribed the police. The medical record that the hospital issued just said that heart failure was the cause, even though the body, and he had photographs, clearly had borne kind of marks of violence and torture. And then there was a whole kind of skerfuffle around the autopsy that never came, and the police sort of closed the case. And it was like an open secret in the village that, you know, this case had been basically blocked from any kind of real investigation, and that the local hospital and the police station were really sort of embedded in networks controlled by this guy who had most likely committed this murder. And because people were scared of him, you know, witnesses wouldn't testify. They basically said, you're nuts, like, I'm not testifying this guy. Next thing you know, I'll be in the fields dead. And I think what that really shows is something that socio-legal scholars really have pointed out in terms of, like, hate crime laws and protectionist legislation generally, which is that, as Pratiksha Bakshi once said, it's really caught in the same field of power that it's trying to address. So, you know, judicial truth is the product of particular documents that get kind of officially marked as carriers of truth. Like, these are documents that carry truth, and they're produced by particular institutions, you know, hospitals, for example. But all of those institutions that make evidence are not separate from they're not outside of the field that produces and lives as part of a casteist society, if you will, that they're part of it, and they're kind of controlled by those same inequalities. So to ask somebody who is kind of doesn't have any forms of capital like that, and who comes from a family that has been kind of marginalized and impoverished for decades, to basically suddenly produce all of these documents to produce a particular kind of truth is sort of absurd. And so basically you have this law which has this aim of empowerment, but it's completely sort of paralyzed by the way evidence works, to put it really simply. So I think that's something it misses out. And I have some thoughts about what it, you know, about the good bits as well, but maybe I'll just allow a little.
Yeah, no, what strikes me in what you are saying is that, you know, we like to think about the judicial system as independent, but of course, it's completely enmeshed in the system. Now, it's not that, well, I don't know, maybe we would disagree on that, but certainly at surface level, it's not that this, the son of this murdered man was meant to be prevented, at least by the law, to bring the evidence. But in practice, it cannot. It's impossible.
Yeah.
So he has no means to manage to bring evidence of the truth. And in a sense, it's part of the context. But then it raises the question of, you know, what can law do? Because what will the alternative be? And maybe as a lawyer, you know, I kind of could think that I may have a suggestion, which would be that in some cases, the burden of proof needs to be shifted from one party to the other. But maybe before we continue as well, because you said you also had some thought on what could be gained. Jessica, is there anything you'd like to bring in?
Sure. Yeah. I mean, maybe I'll take up the what could be gained piece, and then we can flip-flop on that, because I think actually that last point you made is really important, Marie, and questions about whose responsibility who has what kinds of responsibilities towards evidence, right? And I think one of the interesting things about thinking through evidence as an object of study that relates to the law but is also beyond the law is to think about the way in which evidence has itself become, and evidentiary regimes have themselves become, an object of mobilization among social movements. And we were talking about this a little bit earlier in the day when we chatted before, but I think one of the things that I've been really struck by, because I'm trying to do an analysis of something like a judgment or something like a case across multiple nodes in, you know, what I think of as this communicative frame, that one of the things that I've been really fascinated fascinated by is the way in which precisely the questions of evidence or the truth of evidence itself becomes subject to forms of coalition building, forms of organizing, and even forms of judicial self-reflection within the context of the law and the court itself. And so I think that the idea that evidence is malleable in some ways and has a malleable relationship to the truth can be deeply problematic when it comes to these kinds of instances of violence and erasure. I mean, that Sandhya pointed to, or for example, the ways in which states get involved in evidentiary games to in fact erase evidence as they go, right? I mean, and we're seeing cases of this unfold right now in Ukraine. Certainly, you know, the stories about the crematoriums that the Russian troops are taking to burn bodies as they go. But that's only one more recent instance, I think, of the way in which states can use evidentiary regimes to in fact erase violence. But I don't think that that's the only story. I think, you know, correlate to that is actually the way that thinking about evidence as a set of relationships and relational propositions itself becomes a really important way to think about how a mechanism for forcing people within the judicial frame to hear and see you and to make certain forms of violence or discrimination or whatnot visible precisely where they might have been otherwise invisible. And on top of it, to give them a kind of legal imprimatur, right? So this isn't just, you know, changing, this isn't that we're just going to introduce new kinds of evidence. We're going to introduce new kinds of evidence and in the process shift the very interpretive frameworks that judges are forced to use in order to recognize what's legitimate or not. So for example, in the European court context, the most famous case of this is, of course, DH v. the Czech Republic, which was a discrimination case against Roma, anti-Roma discrimination in the school system in Czech Republic, in which a whole coalition of activists and strategic litigators essentially pushed the court to recognize statistics, right, as enough sufficient evidence for, and informal statistics too, because the state wasn't collecting them, but pushed the court to recognize statistical evidence that in some ways was more informal in a finding of indirect discrimination. So the point here, I think, is in some ways the malleability is both a real danger and can be subject to forms of manipulation that reproduce erasures in just the way I think Sandhya illustrated so well in her example. But that malleability can also become a framework for advocacy formally external to the legal system, but with an eye towards actually transforming the legal system internally as well. It doesn't always work, but it's at least a possibility.
Yeah, I mean, I think it's so important not to look at the law as just one separate domain or a domain which in itself can act upon everything else in society. That really, you know, we're talking about a conglomeration of different relationships and events and phenomena, and that is what is going to produce both continuity and change. But you cannot expect one specific institution, even one as big as law, as having an impact on its own. Having said that, Sandhya, what I said.
Sorry, the sound just cut out there for a moment. Could you just repeat that?
No, I would just let you say, you know, you had only given one part. Maybe go to your second part. And
yeah. So in terms of like, I know I've made it sound like the Atrocities Act is like a big disaster zone. And I think, but I do kind of want to follow up on this idea that there are some really positive things that come out of kind of legal institutions obviously taking up a fight against things like caste discrimination. And I think just quickly to Jessica's point, I think it's really interesting to think about like what can be done in terms of like accommodating new kinds of evidence. And one thing that I've heard people say, and this is just one idea, is that what they would like that in India, if you think about India, for example, like caste is often also mapped on like patterns of land ownership and things like that. So one thing, somebody, like one guy once said to me, I wish, you know, as part of kind of what they look at in the court, they would look at kind of land ownership patterns in the area. Like that would be kind of a sort of a necessary way of like assessing what maybe the caste dynamics have been, to just kind of paint a broader picture. And obviously that can't, kind of land records obviously can't stand on their own, but just kind of to introduce that as like almost like a context document. And I thought that was sort of an interesting point. But also just in terms of like the good things laws like that do, I think in my fieldwork, you know, judicial truth, if you want to put it that way, was often like decried as surface level. But the law itself, this attempt of having a law that tackles, you know, that really outlines all of the ways in which casteism still kind of happens, how it can be violent, how it can be in everyday things like denying Dalits or Adivasis like access to certain places, access to water, access to certain religious sites. You know, having all of that kind of in this document, I thought people thought it was very powerful. They thought it was like symbolically powerful for them. It kind of showed them almost the truth of their kind of oppression, like, and it showed that in law, and it acknowledged that in law, and it meant that the state acknowledged that to them, and it was public, and it made them feel like they had something to hold on to now. And there's also this idea, and I think people who've worked on hate crimes, you know, in the global north have said this, that kind of issuing a hate crime law, if the state does that, is almost kind of like a symbolic rejection of particular social hierarchies. It's kind of like saying, you know what, no, this is not kind of in line with the democratic values we as a nation want to uphold. And so there was something powerful like that. And there was certainly some hope really people could find in this kind of textuality of this law, which had like outlined, you know, all of these new entitlements that they had. And it kind of really engendered some new ideas around hope. And then finally, it really kind of did a lot, like the Atrocities Act gave people a lot of opportunities to sort of bring their truth and their justice to the forefront in kind of village interactions. So there were lots of ways in which people often used sort of more informal out-of-court settlements to sort of get the kind of justice or restitution that they were looking for. You know, a lot of the times filing a case, people knew that like going the court route to the end was going to be very difficult, but filing a case would sometimes cause people who had sort of insulted them with, you know, used caste slurs to sort of apologize publicly. It could help them, certain kinds of compensation that are available through the act could help people kind of, you know, buy a piece of land or something, and end dependency on upper caste in other ways. So in a lot of ways, like, you know, laws like this do a lot of work, and they bring a lot of like truths of discrimination to the forefront and allow certain kinds of justice. They don't always do that, you know, in a courtroom with the evidence bundle.
Okay, so again, you know, this idea that we should not look at one phenomenon in isolation from each other. If we just examine what the judicial system produces, we may be missing out a bigger picture, which is also important. So, you know, I think in a sense, to me, that's why talking to anthropologists is so interesting, is that anthropologists will, but almost by their professional commitments, in a sense, and their way of approaching their scholarship, they will put things in a larger context. They will look at a situation in a holistic manner. They will not, in a sense, demarcate. But I think at this stage, I would be quite happy to, well, except if Jessica or Sandhya want to finish the first part of this event by some thoughts. I would be quite happy to open it to the audience, so to all of you who are listening. If you'd like to come in, I would ask you to to show your face on the camera, ideally. Yeah, so Jessica or Sandhya, before we go for some questions, would you like to add something?
Questions are great.
No? Okay, I already see raised hand from Alice. So Alice, we'll listen to you.
Thank you. Thank you.
Gustavo.
Yes. Thank you very much for the conversations. And thank you, Jessica and Sandhya, for sharing with us part of your research. I would have a question. I mean, I have a legal background, but I'm very much interested in anthropologically informed approaches to case law. So both presentations were really interesting to me. And I was just wondering whether you have any concrete suggestions on how to make sure that what Sandhya referred to as experiential, right, truth, how to make sure that this kind of truth emerges. And I'm talking more about scholarship, so not necessarily like on the ground, but like how to reduce the distance between judicial truth and this broader truth that you refer to. I can say, I mean, something that I've already thought about and I'm trying to do in my research. So for instance, I look at the litigant's perspective. So I talk to the applicant. I'm also working on the European Court of Human Rights and like try to understand more about their experiences of litigation. Another thing that I do is I look at litigation more as a process. So I don't focus just on the moment of the judgment, but I take a sort of a broader picture. But I was just thinking whether you have any more additional concrete suggestions on how to really make sure that this broader truth comes to view in a way through scholarship, especially for legally trained scholars. Thank you.
Should we take a couple questions? Should we answer that right now, Marie? Or
I think you can answer that for now, and then we'll go to Gustavo.
Yeah. I'll be quick so Sandhya has a chance to speak as well, but thank you so much, Alice, for the question. And I think it's a really important one. One thing that I'll say, and I think it's an important maybe distinction around socio-legal scholarship and anthropological approaches to law, is that for me, studying an institution like the European Court of Human Rights, I'm interested in the particular dynamics of the institution itself and the experiences of the people that I'm doing interviews with or participant observation with. But my questions are about what work the law does in broader social, semiotic, and ideological contexts, right? So I'm as much interested in the particular evidentiary standards of the court, for example, as interested in that, but I'm more interested in why is it people are invested in particular kinds of liberal modalities or particular kinds of legal approaches to truth in contemporary Europe at this moment in time, right? And so I think one way to get a broader picture in an analysis is to not only ask what's going on with the law, but what does the law do in terms of larger social economical questions in order to, for example, reconsolidate notions of European identity or reinscribe dynamics of East-West, North-South, or think about, allow people to think about justifications for border regimes in the context of violent expressions of state sovereignty, right? So the point is that the law as a social process and fact and space of communication does a lot of work for us socially in a broader context. And so for me, trying to kind of keep my eyes on those larger questions anthropologically is one way that I think we can get to questions about what's erased, who's erased, why, and how, right? I mean, it's that context outside the law as well as the context within it that helps us, I think, get to a degree of relevance. So that's what I would say.
Yeah, I think actually that covers it really well. And I think this, I would sort of just add that I think this emphasis on like, I think it's very, the question of like, why are people turning to this law or not turning to this law, or why do I find it important or not important, actually tells you a lot about the kinds of socio-political issues that are at stake. So actually, when I came to my field side, I remember my supervisor told me, you're going to go there and you're going to try to work on this law, and I'll tell you, nobody's going to be filing any cases because everybody knows that the law is kind of something elite people engage with. But, you know, and that's genuinely kind of what she thought. And she wasn't wrong, because there had been definitely a pattern in a lot of ways. But I got there and people were like simultaneously super disillusioned with the process of this law, but they were really on it, you know, they were like finding ways to file cases and all of that. And I think what that really came down to was that feeling that there was two parts to it, but one was really that other sort of solutions of addressing casteism or caste inequality had failed, like affirmative action policies, like all of these kind of positive routes were failing. So now maybe we think about punishment, and maybe we think about deterrence, or we think about that. And so there was that, and there was kind of like a sense of desperation and a sense of kind of, but also a sense of like very like intense belief that this was the moment, with everything that was going on globally, with, you know, human rights becoming a bigger agenda, with caste being included as a form of racism in the Human Rights Convention, of that this was the moment to like use law. And that was kind of a narrative that had become more broad. And so that really led to this idea that the law was really there for them to sort of work on their behalf and to give them certain like substantive result. And that kind of then obviously also leads into all of these issues then with kind of like looking at truth more processually, and then looking at truth more in terms of like what law is meant to give you. But I think that question of like, why are people turning to this and why is this so important for them? I think that gives you a lot. And that's really just a good way in, I think.
Hi, Alice, does that kind of give you some kind of way forward? Gustavo, can we hear your question, please?
Thanks again for the presentation. And like Marie mentioned, is really like you need to listen to the anthropological version that it gives you several ideas. But I just have one question that for the two of you. What is the role that have the legal communities, the epistemic communities that are surrounding the courts to construct truth? Because I think, and I want your point of view from the anthropological side, because at the end, when there is one narrative, it doesn't go straight to a court, but it goes to a community that is surrounding these courts. And just to give you the example of, especially in international tribunals, it doesn't matter what is the case. You need to go to a specific law firm that specialize in human rights cases. And I'm thinking also about the construction of truth between investor cases and human rights cases. And I have seen how the epistemic community is already having this role, shaping the narrative of the cases that are being brought to even arbitration or a court. So I would like to probably to reflect on that. How this community, not the court itself, but all the specialists, law firms, scholars that are by itself a community with even hierarchy and everything, how these legal communities are shaping truth or narratives in the legal process.
Thanks. Any one of you, like both of you? I think one after the other. I don't know who first.
Jessica, do you want to go first, or?
Sure, I'll just say very quick. I mean, I think it's a great question, and I think it's a really important one. And again, like every frustrating anthropological answer, right? It's a matter of where you situate yourself, right? So these communities themselves are quite diverse and heterogeneous, although often they share professional trajectories, or they may share, you know, they share a space here, right? I mean, it's amazing how much sometimes Strasbourg feels like a tiny village. Where everybody kind of knows everybody else. But I would say there are a lot of very important, I mean, strategic litigation or cause lawyering is one particularly really interesting avenue to think about this. I mean, these are fascinating people, because in some ways, and some of you out there may be involved in this, so you know better than I do, but in some ways what people are doing is self-consciously using both legal and political and social movement strategies and human rights strategies, right, precisely to impact what happens within the court of law, to shape the conditions of judicial truth. And this can take a very, very, very long time, right? And then when you add strategic litigation up to the other side, the implementation side, I think what you see is, to your question, that in some ways it's all about the communities. I mean, what happens within the court or in the accumulation of the case file is really important. But if you really want to understand what makes the law live in some significant way, it's exactly tracking how communities both anticipate and then deal with the unintended consequences of cases. So it's not really an answer to your question specifically, so much as to say, I think you're exactly right that this is where we need to think about looking at the production of truth as a collective project.
Yeah, kind of building on that, I think I would also say that the translation of narratives into judicial truth is really kind of a massive community project. I think, you know, like the examples I've given are very much kind of, they've been individual cases, but I think across the board, the thing that you witness a lot around in India around the Atrocities Act is that people are very aware, that, you know, judicial truth is a very specific thing. And it's potentially different from the way people experience like a broader reality or a broader truth. And people are very strategic about that. And there's basically a wide kind of activist and NGO sort of business, but also like a certain kind of community, like a lot of community organizations that have grown around kind of making this law accountable to the Dalit vision of truth, and the Dalit vision of truth by translating it as best as possible into, you know, the boxes and parameters of a judicially kind of legible truth and narrative. So I think, you know, that you, as you said, there certainly isn't the situation where something happens or there's like an attack against an ex-untouchable person, and then so that person just marches to court. But no, most of the time something would happen, the family would discuss it, and then there was usually like a village meeting where people would come together, and people are really strategic. People like they have this, they'll have the text, they'll have the law, and they will say, okay, we know based on all of these reports and based on this data and based on our own experience with the police, that if we register this case under this section, that actually we're going to run into this and this problem, or like they're not going to want to apply it because this is an issue. People have, there's a whole like knowledge business, so to say, around like making sure that you can correspond as closely as possible one kind of truth with another kind of truth through kind of strategies. And there's a lot of local knowledge that goes into that. So I think it is really, as Jessica said, the most important thing that is happening. And, you know, the law becomes, you know, we think of lawyers being very clever with the law, but this happens way before any lawyer ever gets involved. People, you know, use kind of their local knowledge to make it work for them when they can.
Okay, thank you. Let's move on to Anne. Anne, if you can open your, thank you.
Sure, thank you. Thank you all for a fascinating conversation, both Sandhya and Jessica. I think you bring such unique perspectives to the table, and we all appreciate it. Because I study the European Court of Human Rights, my question goes to Jessica, but permit me to start with two brief comments or observations. The first is to thank you, Jessica, for discussing the case of Louis Zidou, which I think is, well, I almost interpret what you describe as suggesting that the judicial truth encompasses a dimension that one could term a remedial truth, if you will. So what does redress really look like? And are the court's judgments even intended in the first place to provide justice to the victim? Or is the system geared more towards addressing systemic and structural problems that cause all of these repetitive applications? And I would add to this that in many conversations that I have had with interlocutors at the European Court of Human Rights, judges and registry officials, that those insiders would often express the view that this court is not a truth-finding tribunal, but a human rights court, or in the words of one interlocutor, and Jessica used the same notion, a court of law. And many litigators would probably agree that it's not a truth-finding tribunal, sometimes with a sense of disappointment, probably. And there are real implications, in my view, of this self-conception of the courts. Because if this is a court of law and not a truth-finding tribunal, then I think it may seem more defensible that many applications will never result in a judgment on the merits, but might instead get discarded administratively or be declared inadmissible for instance, being unsubstantiated. Now, my question regards judges' understanding both of the notion of truth and their views on the role of the European Court of Human Rights. To the extent that you have discussed this with judges in particular and registry officials, Jessica, I was wondering how judges, let's say, legal upbringing, say in common law systems versus civil law systems, and how their professional experience working as prosecutors, working as academics, working as a family law or a criminal law judge, impact on their perception of the extent to which the court should be a truth-finding tribunal.
Yeah, it's a great question and fantastic comments. I appreciate the way you put that so succinctly, really about thinking about the limits, in fact, of what the court does as in part of the commitment and the ethos of the court, and in fact precisely what gives it legitimacy, which is one thing that I think, one reason I brought up this case, because seeing the different interpretations, seeing the way a judgment, which in some ways is premised on a set of strict evidentiary rules and case law and this, it's a legal document, seeing that then become unpacked as a political document in order to make lots of other different things happen, as the judgment circulates, I think is a fascinating process. Oh, sorry, my connection is unstable here. But I would say in answer to your question about, I don't really do, you probably.
I actually don't hear Jessica at the moment.
They're ruling. Sorry, am I there? Did I freeze?
Yeah, now you are, but you were not for.
I wasn't. Okay. All right. I don't know how much of that you got. All right. I'll try to be short here.
I think you were saying to Anne that maybe they would have.
Yeah. I think you would probably be as well positioned. One of the things that's been helpful for me, though, in thinking precisely about this question is to think of judges themselves not always as intentional actors, right? But as participating in a range of different genres in which sometimes they wear their kind of, black letter law hat, and sometimes they wear their conscience of Europe hat, right? And I find in my interactions or interviews with judges that, in fact, over the course of even an interview, let alone who knows what happens in the context of judicial proceedings, because we'll never know that, but in the context of even an interview, that oftentimes they're, what Goffman would call footing, oftentimes the way in which they position themselves precisely in relationship to questions of truth will shift depending on the particular kind of genre they're participating in. So I've talked to judges who are would consider themselves strictly legalist, right? When talking about the nature of dissent and the importance of dissent can take on an entirely different persona, right? And I think quite self-consciously and they're quite aware of, again, the flexibility of the legal space in order to be able to follow some commitments, right? Or enact certain kinds of statements or commitments depending on that hat they're wearing. And I think judges have a lot more freedom to do that, for example, than registry lawyers because of the particular structure of the institution. But I totally agree with your assessment. I think for me, the interesting question is, if most people in the court that I've talked to consider themselves really to be doing above all else to be doing law, a kind of strict letter of the law, in which consistency to case law is really the most important thing, far more important than any notion of justice, right? Because that's their job. What kind of protection or cover, or what does that enable in the parts of the system that think of themselves as political? And I think we can't separate that. In some sense, the kind of proceduralism of the legal branch of the system enables much more flexibility and creativity on the political side. And so I think taking it sort of as a whole winds up being important in thinking about what's legal and what's political, and the movement between the two.
That's great, huh? This dynamism and this looking at it as a whole, rather than again looking at it as one thing that it needs to do on its own, irrespective of what's happening outside. Ljubko, I think I'm going to give you the last question. So if you could unmute yourself and also show your video, that would be very nice.
Sure. Can you hear me? I can't hear you, but I don't know whether you can hear.
We can.
You can hear me. Okay. Well, I was just wondering, listening to you and also to Anne's comment, I really thought that we should, all of us working on evidence, we should really be careful on how we use the term truth. And I was curious to both speakers today, this is kind of a remark, but I was curious whether you take into consideration normative truth in order to distinguish better what judicial truth might be. Because if I argue and prove that a fundamental right of mine was violated, that means that I have an idea as to how this right ought to have applied, which is a normative narrative, right? It's a narrative about how the law ought to have applied in my particular case, which will then condition the way that I argue, present the argument, present the evidence, and ultimately suggest that a court rule in a certain way. And so I try to influence the judicial truth. So I just wanted to know whether I know that you're an anthropologist, but whether you take into account the interplay between these two levels of truth that are very much interconnected, right? Truth in facts, truth in the law and from the law, and then judicial truth that kind of links the two. And then the second question is more to Sandhya, if I pronounce it correctly. If I understood well the gist of what you were saying is that the procedural abilities of a category of people or a group of people in India are not effective, in a sense that they cannot effectively participate in the judicial process. So I was wondering, well, what is the authority of judicial decisions to them then? Do they accept that a court's ruling kind of gave a decision that they might consider as unjust because inaccurate? And does this then lead you to kind of make a relationship or explore the link between accuracy and justice, and how the two components can be conducive to what we might call a judicial truth? So I hope that got through, and thank you again for a very interesting debate.
Should I just briefly try to respond? Yeah, okay, well, thanks for that. That's a really interesting set of questions. I think in terms of your first part about, thinking a little bit about like the type of truth and normative truth, I think the problem with a law like the Atrocities Act, which really, I talk about it as a hate crime law, but it also isn't necessarily, it is a hate crime law, but it's also more than that. It's a very it has a very broad kind of socially transformative agenda. that's basically, you know, sort of the authorial vision behind it. So there's like elements of like also like civil discrimination, anti-discrimination law, which has kind of become like criminal offenses. So it's very complicated. But I think the issue with the law that promises so much basically is that the visions of truth among the people who are using it, and the people who and the lawyers and judges who are like looking at sort of the wider corpus of criminal procedure and evidence, are very different. So that the bit about normativity that you were saying, this idea that, you know, there I see this as a good outcome and as my entitlement, and I'm kind of trying to construct a narrative in that direction, was very much what legal aid NGOs who were trying to help Dalits like file and pursue cases under these acts were trying to do. And there was an interesting split between like lawyers who worked for legal aid NGOs and lawyers who didn't, in the sense that lawyers who didn't work for legal aid NGOs, or a lot of judges also at the district court in this one city in Rajasthan where I interviewed them, very much felt that these legal aid NGOs lawyers were activists first and lawyers second, and they were trying to construct particular narratives in terms of focusing on what they wanted and what they should get, without any kind of real consideration for the process of the law and for kind of the kind of procedural accuracy, and that so there was the, you know, so there was definitely a split of truth on that end. And I think there was a big debate. You used the word accuracy, and I think there was actually, it's interesting that you use that because it was a word that came up quite a lot, and like different types of lawyers on different sides of these cases accusing each other of being inaccurate in their in their kind of prioritization of the types of truth that were meant to be pursued under this law, and therefore also in their process of approaching it. I'll just leave it at that, but maybe we can have a more, maybe we can have a chat at some point.
I'll just add in one thing very quickly, because I think it's a fascinating question. And the more that I think about it, and the more that I listen to Sandhya's presentation and I'm thinking and reading about evidence, you know, I wonder, I mean, I guess it comes down to some extent what we need the law for. Right? And so the more we think about the possibilities of, for example, the democratization of evidence, which I think is increasingly, I mean, you can see it now all over the place, right? I mean, even as the conflict unfolds in Ukraine, and there's been a kind of a crowdsourcing democratization of evidence, which itself is a fascinating phenomenon, and I think an important one. But the more we think about the non-normative democratization of evidence collection, the more then I think we have to ask ourselves, what work do things like normative evidentiary standards do in places like international tribunals or international human rights courts? And at what point are we talking about the law, right? Truth in the law or evidentiary standards in the law? And at what point have we created something else, a different kind of system for collecting and coalescing around something we want to call the truth, right? That may or may not have the backing, the normative backing of law. And so for me, a lot of these questions, I don't have an answer, but it does lead to the question of are we moving past the law? And if so, what kinds of possibilities allow us to institutionalize epistemic communities where we can talk about questions of justice and structural violence with the kind of efficacy that the law has previously given us, if not the kinds of exclusions that the law has given us? And so for me, you know, I'm really motivated by the idea that we can have alternate institutions to things like liberal legal fora. I don't know what those look like, but that normative, non-normative tension to me really gets at the heart of, you know, we have to be imaginative for what those relationships can look like. So it's time there.
Okay, I think I am going to quickly close this discussion. I mean, to me, there is also the question of what do we mean by normative truth and what would be non-normative truth. And also I see in the chat, Jane Cowan saying that she's especially interested in how to understand procedure and how it can be used strategically, both to in particular to exclude some claimants. And you know, I think this tension also about this between the substantive and the procedural is something that we will need to think about further. I think I've probably already alluded to the fact that possibly, you know, the next episode of this series might be on shifting the burden of proof. But for the moment, I think what I want to do is really to thank warmly our two speakers to get us to think about what is judicial truth in a sense, what does it encompass, what is it distinguishable from, what it helps to understand, what we gain through it, what also it misses. And I think this was an extremely rich discussion.